Appeals from the Crown Court. An appeal against conviction in the Crown Court lies to the Court of Appeal. The prosecution can generally not appeal an acquittal. It is mostly defense who gets the right to appeal in the Court of Appeal against their decision in the Crown Court. The Court of Appeal rarely hears evidence. Mostly, the Court of Appeal sees the case in detail, that whether it was given by following the due procedure of law or not. They consider what happened in the trial and decide whether or not the verdict is safe. If they feel it is unsafe, appeal is allowed, otherwise, it is dismissed. They see in detail what happens throughout the trial, and if they see that verdict was given by following the due procedure of law, then they will not allow the appeal. And if they see that it wasn't given by not following the due procedure of law, then and then only they will give the right of appeal. In an appeal against conviction, the defense will usually argue that the judge misdirected the jury on the law. So, mostly the Court of Appeal deals with the question of law, and if the defense is taking a plea of appeal, the defense will usually say that the jury wasn't directed duly on the question of law and the judge misdirected the jury, and they didn't given a decision by following the due law which was required in the case, or that he had made an incorrect decision of law during the course of trial. The judge has made an incorrect decision during the trial regarding the law. So mostly it deals with the question of law, or that some irregularity occurred in the course of trial. So even if the question of admissibility appears that the judge did not accept a kind of evidence that was admissible and accepted inadmissible evidence, then it was an irregular decision. So the verdict will be unsafe, and the party, the defense mostly, will be given the right of appeal. Usually, the Court of Appeal is the end road of appellant. For the appeal fails, if in this case, it rarely ends up in the Supreme Court, provided that there is a point of law of general public importance involved. Supreme Court generally deals with the question of law of general public importance, and if your case is regarding the general public importance and it is on the point of law, you can appeal to Supreme Court, and it may be in rare cases given the right of appeal. So usually it is not given the right of appeal, but in rare cases where there is question of law involved. A defendant can appeal against his sentence in the Court of Appeal. The prosecution can generally only appeal what they consider to be unduly lenient sentence if the offense is indictable offense. So most usually the defendant is the one who appeal against the sentence to the Court of Appeal, and prosecution gets that right when the decision was quite lenient in the indictable offense. The Court of Appeal only read and consider the question of law and sees the previous case trial from all scenarios, from all branches, that whether it was given by following the due procedure of law or not. And the retrial doesn't happen in the case of appeal in the Court of Appeal as it happened in the Crown Court.